I'm going to hand the floor to Tejas to present the rest of our rich and substantive program today with all of the different experts roundtables that we are going to be holding.
Thank you very much, Professor Cordonier Segger. Indeed, we have a very rich range of speakers for you here today, and we'd like to remind you throughout to use the question and answer function to ask questions of our panelists, indicating which country or region you're from. We have two roundtables for you today. The roundtable 1 will focus on innovations in research and teaching of sustainable development law and governance, followed by roundtable 2 on innovations in training in advancing sustainable development law and governance. And we'll finally conclude with a session on emerging global sustainable development law leadership opportunities to provide you inspiration to take this thinking into the future. It is now my privilege to invite Professor Emmanuella Doussis, UNESCO Chair in Climate Diplomacy, National Kapodistrian University, and a CISDL Governor, to join Professor Cordonier Segger in order to serve as co-chairs of Roundtable 1, Innovations in Research and Teaching of Sustainable Development Law and Governance. Professor Marie-Claire Cordonier Segger and Professor Emmanuella Doussis, the floor is yours.
Well, I'm very, very pleased to welcome Professor Emmanuella Doussis, who is a dear friend and an extremely respected colleague, and to hand to her the chair for this remarkable roundtable. Professor Emmanuella?
Thank you. Thank you, Professor Marie-Claire, my dear friend and colleague. It is my pleasure to welcome you to the first roundtable discussion on innovations in research and teaching of sustainable development law and governance, which takes place on the occasion of the second publication of a landmark legal textbook, a valuable resource for those working to advance the UN Sustainable Development Goals through the rule of law. Well, reforming our economic and political systems to achieve sustainable development and the global SDGs is an urgent necessity. At the same time, we live in a globalized, yet increasingly polarized and fragmented world where rising and unprecedented pressures place growing demands on governance structures and multilateral institutions. Complacency is no longer an option. The challenges we face require holistic strategies and tools that are both adaptive and integrated. Well, with this evolving landscape, sustainable development law plays a crucial role. It has become one of the fastest growing and most demanding areas of legal scholarship. However, traditional legal education often struggles to keep pace with its interdisciplinary scope and practice-oriented demands. So preparing students and researchers to navigate this field requires more than a doctrinal instruction. It calls for pedagogical innovation, cross-sectoral expertise, and critical thinking. As the legal landscape surrounding sustainability continues to shift, so too must the methods used to teach it and research it. So today's discussion invites reflection on how legal education and research can respond to these needs, what the main barriers are, and which approaches better support interdisciplinarity and practice-based learning. So we have with us a wonderful team of distinguished experts whose bio links are available to all in the updated program you have received today. Therefore, I'm going to present them very, very briefly and in alphabetical order. Professor Megan Bowman, Director of the Climate Law and Governance Center at King's College. Professor Jorge Cabrera, University of Costa Rica. Professor Riyad Fakhri, University Hassan I, Morocco, and Vice Chair of the Association of Environmental Law Lecturers in Middle East and North African Universities. Professor Markus Gehring, Cambridge University. Professor Winfried Hack, Professor of International Economic Law and European Economic Law at Westphalia University in Germany. Professor Alessandra Lehmen, University Caxias do Sul, Brazil, and President of the Order of Attorneys of Brazil Environmental Law Commission. Dr. Ernest Kutishat, Law Dean at Soha University in Oman. Professor Pamela Towela Sambo, University of Zambia. And last but not least, Dr. Wu Lan, lecturer at Ocean University of China. Well, as a chair, I'm deeply delighted to welcome you all. You are reminded to stay very, very brief, no more than 2 or 3 minutes for your initial reply to the focus question, please. As you know, we need to be very strict with ourselves so that we can discuss these matters in the roundtable and also answer the questions from the audience. So our first question is, what are the most significant emerging challenges in scaling up research and teaching sustainable development law worldwide? And I would like to invite Professor Winfried Hack, then Professor Pamela, Towela, Sambo, and Dr. IACtHR to give their brief thoughts. The floor is yours, Winfried.
Yeah, well, thank you very much for having me, and I hope that everybody can hear me clearly. And congrats to the authors of this very impressive book. And okay, just turn to my answer to your question. And I would like to start one of the most significant challenges in scaling up research and teaching in sustainable development law worldwide lies in the growing complexity, in fragmentation, the rapid evolution of legal norms across different jurisdictions. And climate change law today can no longer be confined to environmental law. It functions as a cross-cutting legal domain that integrates elements of trade, investment, human rights, constitutional law, administrative law, and private law as well. At the same time, we must recognize the diversity of legal interpretive traditions, systematic and doctrinal reasoning in Germany and the EU, and within the EU, the 27 member states, and their teleological interpretation in international law, precedent-based, case-orientated reasoning in common law systems. We must also include perspectives from critical legal schools like Towela, New Haven, and CRITS that bring additional interpretive layers. Despite these differences, legal traditions pursue a shared goal to establish a transparent methodical framework for understanding the core of what we call law, one that reveals structures of normative reasoning and opens access to real human cognition of a piece of social truth. The recent advisory opinions by the ICJ-ITLOS and the Inter-American Court of Human Rights do not demand, from my kind of perspective, a completely new kind of legal education, but they do call for one that is capable of comparing fragmented legal systems backed by different interpretational standards and methods, and understanding institutional interplay across a various different layer of legal systems, and addressing overlapping or conflicting obligations, always grounded in the specific interpretive and dogmatic background of this respective normative system. This is precisely sorry?
Thank you. Do you have just one last sentence?
Okay, this is precisely where artificial intelligence can play a strategic role, and I would like to stress this point. Yeah, thank you so much. Thank you.
Pamela, you have the floor.
Thank you very much, Emmanuella, and greetings to everyone. Thank you for this chance. So in the research that I do and teaching across environmental law, human rights, sustainable soil management, particularly in the Southern African region and globally, I find that universities have an important responsibility in transforming societies and contributing to the development of a more sustainable humanity. Therein, we find that there are mechanisms for sustainable development law. However, the complexities of globalization, several of them, I'll just talk about a few. The current global geopolitical reconfiguration, international trade distortions, technological advancements, and serious environmental challenges. Important among them, the nuanced climate change issues and effects that we are seeing, particularly in the global south, are compounding teaching and research in so many ways. Further, the assimilation of numerous international decisions that I think in the last few days have come one after the other, and I'll talk specifically about the advisory opinions by the Inter-American Court of Human Rights and the International Court of Justice just the other day. Although they are not binding, they cannot be ignored for research, teaching, and practical impacts that they bring, especially to universities and all the people in the global south. We continue also to look at existing tensions and contradictions through different practices and elevated genuine dialogue, as well as developing flexible structures which look to solving some of these challenges and sometimes contradictions that we will see when we try to discuss the issue of sustainable development law globally, but more so in those areas where the effects are being felt so much in terms of so many other challenges. Thank you so much for this opportunity to speak.
Thank you, Pamela. Agnes, you have the floor.
Yes, thank you, Chair. Well, I'm going to highlight some of the challenges that we face at the Faculty of Law at Sohar University. First, there's a clear gap in the context, especially when talking about legal scholarship, particularly in the Global South, as much of the international literature is rooted to Western legal traditions and doesn't always reflect the environmental and governance realities in our region. And the other issue that we actually face is working to overcome some capacity limitation, as the faculty and students are interested in strong access to specialized training and interdisciplinary partnership. Having said that, the university is committed to enhance the research culture at the university level and have some MOUs to be signed with other universities and higher education worldwide. The most important challenge is related to legal curriculum, remains a very important challenge, as at the Faculty of Law, currently we're trying to update and improve the content and the curriculum of the course profiles which we teach, trying to revise the learning outcomes, to integrate new case studies, especially with the new court's decisions. Hopefully, by introducing these new cases to the students and encourage them to go into depth and research, especially for our postgraduate students, we will have more and more focus on issues related to sustainable development. Having said that, Sohar University is actually committed to SDGs and to work towards having a sustainable development law taught to students worldwide. I hope I'm clear. I tried my best to introduce the main points and to stick to the time limit.
Thank you. Thank you so much for your insightful comments. Now, let me invite Professor Megan Bowman, Professor Markus Gehring, and Professor Alessandra Lehmen to respond to our second question. Well, in light of findings by the International Court of Justice, Inter-American Court of Human Rights, International Tribunal, the Law of the Sea, and other tribunals, what can be done to overcome them and strengthen capacity to improve and implement international law? Megan, you have the floor.
Thank you so much, Emmanuella. Thank you so much, Marie-Claire, to Tejas, the whole team, for bringing us all together for this really incredible event today, and to all of you, of course, who are watching and participating. So in the very brief few minutes that I have for my intervention, I'm actually going to use the ICJ advisory opinion that was handed down just 2 days ago as inspiration for my comments. And I'm going to focus on two things particularly. I think the first area essentially will be the implications of advisory opinions of the ilk of the ICJ, the implications of that for national level litigation and also legislation as ways of implementing international treaties. And I also want to focus in on something that came up in that advisory opinion called the duty to cooperate, and how that can be an inspiration for the work that we're doing in universities and educational settings and advisory settings as well, to overcome the challenges that our first round of speakers identified. So in paragraph 95 of the ICJ advisory opinion, the court frames its inquiry, and it states that it is adopting a broad material scope, that's its words, that encompasses not just state obligations in relation to actions or omissions, but also those of non-state actors within state jurisdiction or the effective control of states, their omissions and actions that result in damage to the climate system and the environment through greenhouse gas emissions. And I think certainly throughout that entire advisory opinion, we get very strong language and messaging, explicit textual analysis and description around what that might implicate. And when we're talking about the trickle-down effect to the national level, certainly I think if we intersect this advisory opinion with corporate level national litigation, national level corporate litigation that we're getting on the topic of sustainability, messaging, for example, from the Milieu de Foncier and Shell decision, particularly the appeal decision by the Dutch Court of Appeal, which reiterates a duty on corporations like Shell to ensure that they are themselves achieving the targets of the Paris Agreement, i.e. not necessarily through state intervention, but through their own interventions. When we triangulate the state obligation to regulate companies together with the messaging around companies have their own duty to regulate themselves, then we begin to get very strong messaging around what I would call the mosaic of responsible climate governance, which includes not just governments, but also companies in civil society. And we'll also see, I think, more implications for national level regulation, which could cover a variety of different fields, from reviewing, reimagining directors' duties in company law to incentives for investment procedures and targets, to potentially even command and control, what we call command and control regulation and legislation that bans and prohibits certain activities or helps to move certain sectors in a transition direction in a much more prompt period of time. And then my final comment is just around cooperation. The duty of cooperation has been stated very clearly in this advisory opinion. And what I love about it is that it talks to the importance of collective action. And certainly that I think is embraced by this sort of event. It's not just cooperation between states, it's cooperation between all of us, between educators, advisors, lawyers, teachers, on these issues to help shape planetary well-being. Thank you.
Absolutely.
Thank you, Megan. Professor Gehring, the floor is yours.
Thank you so much, Emmanuella. Thank you to the co-panelists. delightful to serve on the opposite of a mammal. I must admit, I'm still blown away by the triptych of really foundational advisory opinions on climate change coming from the different courts. We're not only all climate lawyers now, we're all sustainable development lawyers, because you cannot practice refugee law, you cannot practice trade law, investment law, finance law without taking biodiversity, climate change into account if you really follow the advisory opinion. If we agree with the Inter-American Court that maybe there are some aspects of jus cogens obligations, erga omnes obligations in these fields, well, then that has to permeate every domestic legal order. And it should inspire us all to look in our own domestic field, be it national or even local, to analyze whether every state action, every action that is authorized by the state, undertaken by businesses or even private individuals, really complies with these new sets of obligations. And I find that very inspiring. I think we need to see these advisory opinions in a completely new light, right? They are not just for the shelf. They're not just for the United Nations. They should inspire us all to change our legal practice, to really reorient towards achieving the Sustainable Development Goals, towards reaching climate neutrality and stopping the biodiversity crisis. Thank you.
Thank you so much, Markus. Alessandra, the floor is yours.
Thank you. Thank you so very much for having me. It's truly wonderful to be here among colleagues and friends from the sustainable development legal community at such a momentous time for climate law. I'll be brief, as there is, of course, a lot to unpack with regard to the advisory opinions. And with regard to teaching and research, I wanted to comment on two main aspects that were immediately evident this week as I taught my PhD class on climate law here in Brazil. The first aspect is, of course, on the importance of the opinion for climate law. This week, my PhD students had the opportunity to compare all three advisory opinions, which was a fantastic exercise in the sense that several of the concepts that we have been discussing thus far regarding state obligations, and particularly, as Professor Bowman already highlighted, the relationship between international commitments and domestic policy, and also the legal foundations for climate litigation. So these concepts gain new meaning, and as a result, they were easier to grasp, and most importantly, they sparked new ideas, which is exactly what we want from students. And the second aspect reflects on the importance of legal education itself and the role that students can play. So I think that upon learning that the case stems from a campaign, the ICJ case stems from a campaign led by 27 students from the University of the South Pacific in Fiji, current and future students will be incentivized to take on a more active role with regard to countering the climate crisis, which would, of course, be wonderful to see. Thank you very much.
Thank you so much. Finally, let me invite Professor Jorge Cabrera, Professor Riyad Fakhri, and Dr. Gulan to give us one or two thoughts each on our last question. How can legal and interdisciplinary research and teaching adapt to address rapidly evolving sustainability crises, emerging legal frameworks, and new decisions of courts and tribunals? Jorge, you have the floor. We can't hear you. Can you please?
Sorry. Thank you very much for your kind invitation. It's really a pleasure to share with you some of my views regarding the impact of this decision, as well as the impact on teaching and on multidisciplinary research, in particular in this area of the world, in Latin America, Central America, South America, in a way. I would like perhaps only to share a few few points about the relevant impact of these decisions for teaching and the relevant impact of these decisions for sustainable development law. I mean, for the advisory opinions. One is, I think, and I share that fully with Markus, that we are now looking at international environmental law or environmental law, not only in isolation, but looking as well as other international regimes such as human rights, economic international law, health law. By the way, the WHO recently adopted a new treaty on pandemics with some components on equity and on access and benefit sharing. The second thought perhaps is the cross-fertilization between human rights courts that we are seeing in different decisions, not only on the advisory opinions, but also in other cases where there is a lot of cross-reference to the decisions made by other international courts and tribunals. And the third thought is that here, at least, especially in Costa Rica, we are looking at a growing impact of these international decisions, this case, advisory opinions or regular cases, in the national jurisprudence. For instance, in the case of the Constitutional Court of Costa Rica, there are several decisions made, several cases where the former opinion, the C-2317 of the Inter-American Court of Human Rights on environmental issues, requested by Colombia, are quoted and are utilized widely in the decision making of these specific cases. So we are also looking clearly at a key role of jurisprudence in the shaping of national law here in Costa Rica, and as well as the need for multidisciplinary research. Thank you very much.
Je pense que Mazel, j'interviens, Mazel, donc je vais rentrer chez moi, je prendrai mon intervention. Merci. Donc oui, pardon, je voulais te dire bonne route. On se voit la semaine prochaine ou pas?
Professor,
you
can
are
you
muted
please
again.
mute? Thank you.
Please unmute.
Okay,
Jorge.
mute, please.
Sorry, yes.
If you want to just make two last quick points.
Yes, I think perhaps one very relevant point is that we are also looking at a more complex landscape in terms of international law, not only because of these decisions or the opinions, but also because the emergence of many international law new frameworks, such as the WIPO Treaty adopted last year on traditional knowledge and genetic resources, the BBNJ agreement about to enter into force, the plastic treaty negotiations, the WHO recently adopted pandemic treaty, and the negotiations for the enhancement of the international treaty on plant genetic for food and agriculture. So the landscape of international law is becoming more complex, is growing exponentially, and the interaction with national law as well, I think, is growing exponentially. So we will be seeing in the next years how these interactions are really taken into account and reflected in national decision making, in national jurisprudence, and in the amendment and change or emission of new and innovative environmental law provisions. And that's something that we are experiencing right now here in Costa Rica with former.
Thank you so much.
Thank you.
Professor Riyad Fakhri, the floor is yours.
Yeah, good afternoon, everyone. It's truly an honor and a pleasure to be part of this distinguished panel today, and also extend my sincere thanks to CISDL for organizing this pivotal event. So how do we adapt? I believe that this question, we must fundamentally shift our approach in three key areas. First, I think in our research, we must move beyond traditional siloed legal analysis. We need to embrace interdisciplinary research. This means our legal scholars must actively collaborate with climate scientists, engineers, and economists. For example, to truly understand the legal challenges of carbon capture technology, we must first understand the technology itself. Second, I think in our teaching, we must prioritize experiential and dynamic learning. Our students we need to integrate real-world case studies, moot courts, and simulation into our classrooms. By doing this, we equip students with the practical, actionable skills that we need in the future. And the third one, and finally, our curriculum, I think, must become more flexible. We should design programs that can quickly integrate new laws and court decisions. We must also look beyond our own faculties and explore joint projects, our courses with engineering, public policy, for example, and also business schools. Why not? The goal is to build a new generation of legal professionals who speak the language of sustainability in its entirety. In essence, we must move from a static, reactive model to a dynamic, interdisciplinary, and proactive one. And by doing so, we wouldn't just teach the law of today, but we will sure empower the legal minds who will shape the sustainable future we all need. Waiting for the question, I thank you.
Thank you. Thank you so much. Last but not least, Dr. Wulan, you have the floor.
Thank you, Professor. I think to address this, we need a global network for sustainable development educators like this to share knowledge, especially between the global north and global south, and also between early career teachers like me and also other more experienced educators like our Professor Cordonier, Segger, and other professors here. As a very young lecturer, I'm still figuring out how can I turn what I've learned to what I can effectively teach. But there are not many chances for me to hear from other experienced teachers about how they deal with this very fastly developing sustainable legal framework internationally, and what topics they prioritize and how they engage students or how they deal with some sensitive or complex issues. So for me, it's really important to learn from other experienced educators. And that's why I think what Professor Cordonier, Segger and her teams in CISDL is doing here is very meaningful to helping us to join this kind of global conversation on how to teach sustainable law in a very critical and engaging way. So this is my reflection on this question, and thank you very much for this opportunity to speak here.
Thank you. Marie-Claire, the floor is back to you.
Thank you. And we will be very, very honored to hear from our moderators, Yushi and also Muskan, who have collected some of the questions coming in online. I will come back to three of you, and I'm going to pinpoint you to answer these questions they've collected. And then we're also going to have a second round of discussion after the second roundtable has had a chance to give their initial thoughts so that they can come in at the last minute. So what we will do now is just ask if everyone can be spotlighted on the screen from this first roundtable and hand over the floor to Muskan to share two questions that have been asked by multiple people on the chat. Right, I'm going to be asking Yushi to share. Thank you, Yushi.
Thank you. Thank you, everyone, for all our speakers for your insightful sharing, which has indeed resonated with many participants in this room. First of all, I want to address some audience questions. The slides will be shared after the session. And we have seen strong engagement from a wide range of regions. Sorry for being unable to share all of the fantastic questions, but there are indeed two questions of shared concern and curiosity, which can be summarized into two key words. One is implementation. Geoffrey from Malawi, Mohammed Bello from Nigeria, Mohammed Hossein from Iran, Halfa from Ethiopia, And Antwi from Ghana, Abigail from Sweden asked, how can we strengthen the enforceabilities and implementation of sustainable development law and climate-related obligations, especially in countries facing political resistance, weak legal infrastructures, strong fossil fuel interests, or even deregulation movements? And the second question, the second keyword is equality. So Flora from Sierra Leone, Tasbilha from Pakistan, and Samuel from Israel, Leslie from Canada asked, how can educators and the legal institution promote climate justice and interdisciplinary learning, particularly in global south contexts, where addressing structural inequalities and linking global education with real-world change? And these are the two questions.
Excellent. I'm going to turn to Professor Jorge Cabrera and also Professor Megan Bowman to help answer the question about implementation, if you would. And I'm also, in terms of equality, going to ask if Professor Pamela Towela Sambo and also Professor Alessandra Lehmen might be able to answer that one. And I'm coming back to other roundtable participants in the second round after roundtable 2. So don't worry, you will also have your chance.
Okay, thank you very much, Marie-Claire. Yeah, I think implementation is a key word in sustainable development law and in environmental law. And we, of course, at the national level are looking to strengthen the level of implementation of our international and national obligations. In the case of Costa Rica, and I would like to highlight the key role of the jurisprudence, especially of the Constitutional Court, like Sala Constitucional of Costa Rica. I mean, in highlighting the obligations related not only to climate change, because we have some cases of climate change, but in general in sustainable development law or environmental law and the right to a healthy environment. So I think in our case, at least, the role of the tribunals has been key, I mean, in forcing institutions, I mean, to fulfill international and national obligations. Fortunately, we have a set of different bodies, including at the judicial level, I mean, in charge of secure or promote implementation, but especially in the case of the Constitutional Court, they have issued in the last 1 or 2 years, at least 8 to 10 key cases, not related especially with climate change, but in general with biodiversity conservation, species conservation, protection of water resources, and the integrity of protected areas. All of those are, of course, related to climate change in one way or another. Thank you very much.
Absolutely. And just for those who don't know Jorge very well, he has worked all across the world with UNEP, UNDP, IUCN, and others, actually assisting megadiverse countries to adopt the implementation laws that are needed, not just in Costa Rica, but in Nepal and all other countries, in order to implement the entire biodiversity regime. So you're speaking from a place of great expertise, Jorge, and thank you for that.
Thank you very much.
Megan, given your work on finance internationally, I would love to hear your thoughts.
Well, thank you so much, Marie-Claire, and thank you so much for the questions. So my understanding from the nature of the question is that implementation can be difficult, especially in countries where there might be an unambitious or recalcitrant government, or the rollback jurisdictions where there's some kind of regulatory rollback, as we're seeing in America and Europe as well. And it's such a great question, and I want us to keep talking about this question, because I genuinely cannot answer the question with a silver bullet answer. I wish I could. What I can do is I can throw out some ideas, but I urge everyone here to keep discussing this issue of implementation, particularly in contexts that may not be amenable to it. So where I want to begin with is, of course, this is always a thing with international law implementation. We have plenty of good international lawyers on this call today that and we just need to look around us to know that there have been a number of occasions throughout the decades where ICJ decisions, let alone advisory opinions, have not been complied with. What I'd like to focus on, I think, is more the authoritative nature of this opinion, and that can never be underestimated in terms of the variety of contexts in which it can be deployed and utilized. So we see, you know, throughout a variety of national as well as international courts, these sort of advisory opinions, and particularly this ICJ one, will be used you know, very deliberately. And the other thing that I want to emphasize is that every one of us, when we talk about implementation, we immediately start thinking about litigation, legislation, regulation, enforcement. I would like us to start thinking about implementation in terms of the way we do our everyday tasks, the way we have conversations with our students and with our peers, the way we walk into our boss's office and say, this is the direction of travel. What are we doing to not resist it, but to ride the wave that is not just coming, but is here now? And even better, I got some ideas, you know? They're the kind of conversations I think that help to implement. Yeah, thank you.
Excellent, thank you. On equality, of course, there's no better person to ask than our Human Rights Commission member, who I met just recently. Again, I love running into her in the Baku climate change negotiations, where she was just returning from an international human rights meeting. So, Professor Pamela, what do you think?
Thank you very much, Marie-Claire, and to the question that's been asked in relation to equality. So when we look at equality, I'll address it in the context of climate justice. And there are so many ways that we can address this question. I'll just try to bring some that can sustain the conversations and how we look at them. So first and foremost, when we look at the issue of climate change and its effects, it is not selective. We may come to an observation that in the global south, there have been some very vulnerable populations that have been adversely affected, but that does not leave any of the other parts of the global north less vulnerable. So we need to look at it on that basis, I know. And I know what I have said is still open to so many more explanations and questions. But when we turn now to look at a human rights-based approach towards the issues that we are facing and which are cross-jurisdictional and affect the entire globe, we need to understand that we already have a well-developed, and it still continues to develop, human rights framework across the globe, which ultimately should not leave anybody behind. So within those contexts, we even see some of the judgments, advisory opinions coming out, and we're just anxiously waiting to see the African flavor that we will have to what we've seen from the inter-American and the global perspective. I have no doubt that even in the context of the African court approach towards this vexing problem of climate change, climate justice, the starting point is going to be issues of equality. And as I said, let us try to look at an approach that is human rights based. I think when we look at the supranational level, and we also look at what is happening in country, and that brings me to specific focus in terms of in country. When we start at the local level and focus on workable mitigation and adaptation approaches, it seems we'll start again from the basis of human rights, justice, and issues of equality. So that's my take for now, but it's a question that needs a thesis.
Well, you can count on us when it comes to the African Court of Human and People's Rights advisory opinion, which we all await eagerly, that procedure. I'm going to turn last for just 2 words from Professor Alessandra, who of course will be hosting us in Belém and very front and center for the next year for the COP30. Professor Alessandra, equality in the Amazon.
Yes, yes. So I'd say that thank you again, Marie-Claire. As I mentioned earlier, I live in Brazil. I live in an area that was devastated by floods last year. So there has been forcibly a huge shift in perception from the public, meaning that the real world element is very much present, and inequality is also a very important part of this equation. So circling back to the question on legal education and the role of academia and lawyers, I'd say that very briefly that to address the real world change that we need, particularly in the global South, I'd say that we need to strike a balance among providing high quality legal education, sparking interest from a new generation of climate lawyers and academics, but also, I think, taking it upon ourselves to communicating these issues clearly outside the walls of academia. Thanks very much.
Thank you so much to all 4 of you, and Professor Winfried, Professor Markus, Dr. Inas, Dr. Yu. I'm going to come back to you in the final round, but we will now pass the floor with great thanks for her patience and for her understanding to Professor Nandini, and also, of course, to Professor Damilola as co-chairs of our second